Good morning. Thank you so much for attending today's training. You're probably attending this training because you are scheduled to work at an expungement clinic. Thank you so much for agreeing to volunteer. We'll go ahead and get started. The expungement training today is being brought to you by the Mississippi Volunteer Lawyers Project. Let's start off. What is an expungement? An expungement is the deletion or striking of an offense from an individual's criminal history record. In Mississippi, this has the same effect as restoring someone to the status that they occupied prior to committing the offense or even being arrested or indicted. There are two types of crimes in Mississippi. There are misdemeanors and there are felonies. Misdemeanors are typically less serious offenses that are punishable by less than a year, whereas felonies are typically more serious and are punishable by more than 1 year. You'll see with felonies that there are basically two categories. There are violent offenses such as murder and aggravated assault, and then there are non-violent offenses such as drug charges, etc. There are many types of expungement petitions and there are many statutes that we have drafted different petitions that you will see later on, pleadings rather, that are specific to each of these statutes that you see here. We have one for arrest, meaning that a person was only arrested, one for dismissals, one for first offense misdemeanors, multiple misdemeanors, DUIs, adult felonies, felony non-adjudications, and pretrial intervention. Let's dive into it. Misdemeanor dismissals. First, we have arrest. This means that an individual was arrested for a misdemeanor and was not charged within 12 months of that arrest. If that occurs, then an individual is entitled to have their criminal history record expunged and have that charge removed from their record because it is equivalent to being a dismissal, being that there's no disposition in the case after 12 months. And that is specific to misdemeanors. Regular dismissals. This typically happens when there's an order of dismissal. For whatever reason the case was dismissed, that person is also able to petition the court to have their record expunged. Another form of dismissals, and this is going to be under 99-15-26-5. This statute is more particular when there is actually court-imposed conditions. And what I mean by that is if an individual's file is retired to file or passed to file, so long as they don't have any other offenses for the next year, then that's a situation where if the charge itself has been dismissed, however, it was dismissed based upon court imposed conditions. And for that reason, we need to use 99-15-26-5 to remove that from their criminal history record or to petition the court to remove it from their criminal history record. Misdemeanor convictions. I just want to make a distinction here that dismissals and convictions are two different things. Dismissals, of course, mean that the person was not found guilty. Convictions, on the other hand, mean that the person was found guilty. So we have the first offense misdemeanor statute. So with this first offense misdemeanor statute, an individual can have any first offense misdemeanor removed from their criminal history record or can petition the court to have it removed from their criminal history record so long as they are a first offender. This differentiates from what you will see next because in the next statute, which is a multiple misdemeanor statute, there is a waiting period. There is no waiting period if they are a first offender. What does this mean? If a person yesterday was found guilty of a misdemeanor offense, they paid their fines and fees, and they've completed all actions that the court has asked them to complete, they can walk into our offices the very next day and have their record expunged so long as they have completed all terms and conditions of their sentence. Multiple misdemeanors is a little bit different, and you'll see two different statutes here. The first statute is for justice court. The second statute is for municipal court. Depending on whether the charge was had in justice court or municipal court, that will determine which statute you use. They basically say the exact same thing. They say that in open court, you must show rehabilitation of a good conduct period of 2 years since the last conviction in any court. And so once you've done that, you can have multiple misdemeanors removed from your record. What do we mean when we say multiple misdemeanors? Multiple misdemeanors just means that that person has more than one conviction of a misdemeanor. Could have been 10 years apart. It could have been right there together. They could have got two charges at the same time. That person would need to fall under these statutes as opposed to the statute that you just saw in the previous slide. If an individual has multiple misdemeanors, if they're in the same court, we typically do those in the same pleading. If they're in separate courts, of course, you're going to have a separate pleading for each misdemeanor. And so we just want to remember here that it must be 2 years from the date of their last conviction in any court. What does that mean? That means that if an individual got a misdemeanor charge way back in 2010, and then in 2021, they just got a second misdemeanor charge, and they come to our office tomorrow and say, okay, I want to have my record expunged. They cannot have their record expunged until 2 years have passed since their last conviction in any court. That means that they cannot have the charge from 2010 expunged, nor can they have the one from 2021 expunged yet. They must wait 2 years to show a good conduct period. DUIs. DUIs work a little bit different, and the main thing that you want to remember is that for DUIs, it must be the person's very first offense. If it's not their first and only offense, a DUI cannot be expunged. Let me say that again. If it is not the person's first and only offense, the DUI cannot be expunged. There are a long list of other things that would make a person not be eligible to have a DUI expunged from their criminal history record. One of those things is if they are the holder of a commercial's driver's license or a commercial's learning permit. If they are the holder of a commercial's driver's license or a commercial learning permit at the time of the offense, that person is then not eligible to have that removed from their criminal history record. Okay. In addition to that, they must wait 5 years until they successfully completed all terms and conditions imposed by the court in regards to this conviction. Other things that will keep an individual from getting even a first offense DUI expunged are as follows. The person must successfully complete the conditions. We just spoke about that. The person must not have refused to take a breathalyzer or refused a blood test. Even if they do take that test, their blood alcohol concentration level cannot be over 0.16. So if they come in at above 0.16, they are not eligible to then have that offense removed from their criminal history record. They must not have any other pending driving offenses or DUI offenses, and they must provide justification to the court as to why the conviction should be expunged. And so DUIs are very particular, and as I mentioned, there are a lot of things that could potentially keep a person from getting a DUI expunged, especially if that person has a DUI second or a DUI third, or as you'll learn in the next couple of slides, a felony DUI. Going right into felony dismissals. Felony dismissals are very similar to the misdemeanor dismissals. You use 99-1971-4 if there's just an order of dismissal. And so that means that for whatever reason, there is a no true bill or no pros. For whatever reason, that person was not charged with the offense and received an order of dismissal as a result. And this can typically happen where the charges are dropped against the person, an arrest was made, and then there was no disposition in the case, or the person was found not guilty at trial. We see this second dismissal again. The second dismissal is no different from the one that we just discussed in misdemeanors. It's 99-15-26-5. Once again, this just means that the court imposed some type of condition on the dismissal. And so the court said, so long as you complete these conditions, we will dismiss this from your criminal history record. In that case, where you have court imposed conditions, we want to make sure we're using 99-15-26-5. Felony non-adjudication. Non-adjudication is equivalent to a dismissal. In fact, it may result in an order of dismissal. Typically, in this case, the person pleads guilty, and upon their guilty plea, the court withholds that guilty plea and asks the individual to complete a certain sentence. Once that person has completed that sentence, the court then grants an order of dismissal, dismissing that charge based upon their completion of the terms and conditions that the court imposed. And so we would still use, I still like to use 99-15-26-5 in this case, because they're still imposing some court condition, and upon that court condition, then they're non-adjudicating or dismissing the case. Pretrial intervention. Pretrial intervention is also equivalent to a dismissal because this means that the person never goes to trial. This means that the person has received some court-imposed condition, and based on that court-imposed condition or their completion of that court-imposed condition, they are released from having that charge on their criminal history record. Felony convictions. Here is the one that you may see the most. Felony convictions. A person can have any one felony offense or any one felony conviction, rather, removed from their criminal history record so long as it has been 5 years since they've successfully completed all terms and conditions. The important thing is to remember here is even though we're saying any one felony conviction can be removed from a person's criminal history record, there's a long list of things that cannot. A crime of violence, for example, arson, trafficking in controlled substance, a third, fourth, or subsequent DUI, a felon in possession of a firearm, failure to register as a sex offender, voyeurism, witness intimidation, abuse, neglect, or exploitation of a vulnerable person, and embezzlement. The list that I just gave to you all is the list of offenses that are not eligible for expunction no matter how many years have passed since the offense was committed. Another little caveat I want you guys to remember is that a person is eligible for only one felony expungement. However, if for whatever reason multiple convictions arose from the same common nucleus of operative facts, the court in their discretion can still grant multiple convictions to be removed from a person's criminal history record so long as all of the convictions arose from a common nucleus of operative facts. Next, we're going to go right into what are crimes of violence, because I just told you that crimes of violence are never eligible at this point to be expunged from your criminal history record. What are these crimes of violence? These crimes of violence include the things that you see on the screen right now. That's driving under the influence, murder, attempted murder, aggravated assault, manslaughter, killing of an unborn child, kidnapping, human trafficking, drive-by shooting, gratification of lust, shooting into a dwelling. And so you guys can take a deeper look at this list because I didn't state all of them just now, but this is the detailed list with statutes of all the crimes of violence that cannot be removed from your criminal history record as a conviction. If you see any of these offenses as a dismissal, those can be removed from an individual's criminal history record. On to what information we are required to use in the pleadings. We need the person's name or any aliases. If the person, for whatever reason, no longer goes by, for example, if they were Jones at the time of the offense and now they are Mayweather, we want to make sure we're putting both names. We want to make sure we include the case number, the charge, the arresting agency, the arrest date. All of this information is going to be obtained in the court documents that we have. The court documents are going to depend on who did the arrest or who the arresting agency was and where the arrest happened. Now we're going to talk about what are these documents? What are these documents and where do we get them from? So typically you may have a background check and or an arrest record. We do not require that you have those things, but sometimes it's a good point of reference. For misdemeanors, we specifically want an abstract of court record. That abstract of court record will typically tell us whether or not all fines and fees have been paid, and it will give us all of that information that we just listed previously. For example, the arresting agency, the arrest date, the charge itself. It gives us all the pertinent information we need in order to complete our pleading. And so again, that record is called an abstract of court record. And that can be received at the court in which the offense was disposed of. So if a person is in Hinds County and they're arrested by the Hinds County Sheriff's Department, the Hinds County Justice Court is going to have their abstract of court record. If that person is in the city of Jackson and the city of Jackson does the arrest, then that person's abstract of court record is likely going to be in the municipal court, the Jackson Municipal Court. So for felonies, we need a few more documents. I normally recommend that we have 3, and you can get this from the circuit court in which the case was disposed of. And so that's an indictment, a sentencing order, and a discharge order. Those are going to be very important for felonies. That indictment is going to tell us the date of the offense. The sentencing order is going to tell us how that person was sentenced, and their discharge order, if they served any probation time, is going to tell us when that person completed every single thing that they should have completed to have successfully completed the sentence. And so that essentially is where we start counting 5 years, because with a felony, it must be 5 years since you completed all terms and conditions before you can have it removed from your criminal history record. What does that mean? If a discharge order says that a person was discharged successfully in 2017, that person then is not eligible to have their record expunged until 2022. We must wait 5 years from the date that's listed on the discharge order. And again, for felony offenses, you can always retrieve those documents from your circuit court. Here we have a question for you. You guys can take a minute and pause and read this question, and then we'll go straight into the answer for this question. All right, if you said misdemeanor, you were correct. Jacob would be charged with a misdemeanor shoplifting charge as the top total of the amount stolen merchandise was under $500. Next, we have the question of, can this charge now be expunged from his criminal history record? If you say yes, you are absolutely correct. If this is Jacob's very first offense, then he can have this expunged as soon as he's completed all terms and conditions. If for whatever reason this is not his first offense, he must wait 2 years from the date of his last offense before he can have it removed from his criminal history record. Let's assume Jacob was coming to the clinic. What will we need to do for Jacob? Jacob would provide us with an abstract of court record. It looks like here Jacob would have a Hinds County Justice Court abstract of court record, meaning that the sheriff's department did the arrest. And so when the sheriff's department did the arrest, they sent it over to Hinds County Justice Court, and we got all this information. As you can see here, we have the name, the docket number, the city, the charge itself, the judgment of the court, and whether or not the fines and fees were paid. And so this is the type of document that you will see at the clinic. The next thing you're going to need to do is go ahead and start preparing Jacob's misdemeanor motion and order. And so, like I told you, these will already be fillable forms. You already have access to these documents. You will simply go in and fill this document in, ask the client whatever questions you need to ask the client. But I will rely heavily on the abstract of court record in this case. All right, we have another scenario. I'm going to give you guys a second to read over this one. Is this a misdemeanor or a felony? If you said felony, then you are correct. Jacob would be charged with a felony shoplifting charge as the total of stolen merchandise exceeded $500. Can the shoplifting charge be expunged? Can a felon in possession of a firearm be expunged? The answer here is yes and no. Yes for the shoplifting, and no for for being in possession of a firearm. So under our statute, any one felony is expungible so long as it does not It is not contained in that long list of felonies that cannot be removed from your criminal history record. And so shoplifting is not in that list. However, being a felon in possession of a firearm is. What does this process look like? First, we'll complete intake where we gather all their personal information. We'll review the documents that they bring to us, be it an abstract of court record or an indictment or sentencing order or discharge order if it's a felony. We start petition drafting, which is what we need you for. The person is going to be responsible for filing their own document, pro se. There may be a hearing. If that is applicable, we will inform, by we, I mean Mississippi Volunteer Lawyers Project, will inform the individual of what they need to do during that hearing. And then the person will either receive a letter granting or denying their order. And then the MVLP provides with some follow-up to make sure that the person got everything completed okay. If there are any questions and concerns, you guys can feel free to reach out to me. My email address is swilliams@mvlp.org. I am very open to any questions or concerns that you have in regards to tomorrow's clinic or the clinic that is in the future. Here are a couple of things that we don't want you to forget. If you're attending the clinic in person, please make sure that their retainer agreements have been signed. Their retainer agreements will be contained in the folder in which you will receive with the person's intake form. Make sure you're using the accurate pronouns. You will see a lot of he, she. If it's a female, make sure you're using she. If it's a male, make sure you're using he. Label the exhibits. There will be exhibit stickers provided to you. Make sure you're labeling those exhibits that we mentioned. The abstract of court record would be an exhibit. In the misdemeanor cases and in the felony cases, the indictment, the sentencing order, and a discharge order would be the exhibits. Remember that Harrison County, Hancock County, and Stone counties use specific petitions. Those petitions will be included on the jump drive that you receive at the clinic or in the Google Drive where I will drop the pleadings. Please ask as many questions as you have, whether those questions are for your client or MVLP. Make sure you review the pleadings, read over everything, make sure it makes sense, make sure nothing's out of place. That'll also help with using the accurate pronoun. Remember that the client represents himself. Remind the client that they are responsible for filing these documents on their own. However, we're going to give them all the necessary tools that they need to do so. The client is also responsible for all filing fees. MVLP is not going to be responsible for those filing fees, nor are you. The client himself must prepare those filing fees. Generally, sometimes in municipal court or justice court, we'll see those filing fees range between $50 and $100. And in circuit court, we see those fees range from anywhere from $100 to $200. Please be reminded as well that MVP is available for any follow-up to the client. You are not responsible for giving the client your personal contact information. If that client has any questions or any issues, that person is to contact the Mississippi Volunteer Lawyers Project after the clinic. We appreciate you guys so much. Thank you so much for volunteering. Thank you so much for lending your hand. I'm more than sure that our clients appreciate you. And just know MVLP definitely wants you to know that you are appreciated. Thank you so much. If you have any questions, again, my contact information is swilliams@mvlp.org. Thank you.